Hello, and welcome to Advisory Explained. I'm your host, Kosie Kritzinger. Join me in this series, this podcast where we discuss the complex world of advisory. We dive deep into very specific topics in the world of mergers and acquisitions, due diligence, tax, fiduciary services, and so much more, where we take complex topics and we break them down into smaller, bite-sized, palatable portions for you to understand and to understand where we can assist you. Welcome back to another episode of Advisory Explained, where we take complex topics and we break them down into easy, digestible points. Today, I am very privileged to have Dr. Albertus Marais with me, and we are going to discuss GAAR, but specifically the difference on the new Taxpayer G case. Albertus, welcome.
Thank you, Kosie. Good to be here.
Albertus, before we start, can you give the audience just a quick background, who you are, what you do, and sort of what's your role?
Kosie, I'm a tax practitioner, practice at AJM in Cape Town. We have branches in Cape Town, Johannesburg, and Windhoek. And we specifically deal with tax matters. So tax consulting, and my own interest and speciality lies in tax disputes or tax litigation.
Fantastic. So I know we're going to discuss GAAR, but we have done a high-level discussion with one of your colleagues, Bobby. So if you guys want to have a look at that episode, there will be a link in the description for you guys to follow and have a look at that. Great idea to look at that before you actually listen to this so that you have a bit of a better understanding on what is GAAR, General Anti-Avoidance Rules. Albertus, however, before we jump into the case, Taxpayer G, if you can maybe just give like a 1 minute GAAR, Section 80A, just sort of what it is before we kick off.
Yes, because I think it's very important to appreciate that, and we have a number of judgments that have confirmed this, that there's nothing wrong with tax avoidance per se. And taxpayers are perfectly entitled to arrange their affairs as tax efficiently as possible, provided that you don't fall foul of this General Anti-Avoidance Rule. Now, what the General Anti-Avoidance Rule or the GAAR involves, it's in Section 80 capital A of our Income Tax Act, and it says that you can't do anything simply for tax purposes abnormally. Of course, there's an important rider there. Very often people will tell you across, the Braaivleis fire that, you can't do anything for tax purposes. That's not the case. You can, of course, do anything for tax-related reasons, as long as it's not abnormal. Also, if you have an option to structure a transaction in more than one way, you are perfectly entitled to pick the manner or the way in which to do it that brings about the least amount of tax payable for the taxpayer. So this case that we're going to discuss now is an interesting one, and it's long awaited. Why it is important for us tax nerds is that it's the first case dealing with this very important rule that is a blanket across the Income Tax Act, this idea that you can't do things abnormally for tax reasons only. We've received an entirely new and reworked rule, GAAR, in 2006 in our legislation. Previously, the old GAAR was in Section 103, and it was completely redrafted in 2006 into a GAAR that was up to now untested. We had no cases dealing with it whatsoever. So that both suited SARS and did not, as well as practice or industry, because of the uncertainty created. And the GAAR is therefore always, this blunt threat instrument that SARS can threaten. So look, I'm going to apply the GAAR to a certain transaction. But now we're starting to get some idea of how the courts may approach it, what some of the uncertainties would involve, and how these may be resolved when they go forward. So we're all very interested in this case. Of course, tax court cases are anonymous, all of them. It's not open to the public. Gets reported, but in anonymous fashion as well, in redacted fashion. So we refer to Mr. Taxpayer G as the taxpayer, the appellant in this case. But of course, that's a person. We just don't know who that person is.
Fantastic. Thank you very much for that. I think while we kick off specifically on Taxpayer G, can you maybe give a high-level overview of what was the case about?
Yeah. Look, many won't remember, but about 13 years ago in 2012, we still had the STC regime in this country before dividends tax. So dividends tax only been around for 13 years. Dividends tax is, of course, a tax that's being levied on taxpayers, shareholders receiving dividends from companies. Now, before that, prior to 2012, we had the secondary tax on companies, STC, which was a tax on dividends also, but it was levied against companies. So the theory behind it, at least, or the policy, was to discourage companies from declaring dividends out so that it retains profits and reserves rather to reinvest and to encourage economic growth rather than to give it back to shareholders. But in order to align with the rest of the world and with our treaty partners, etc., STC was abolished in 2012 and replaced by dividends tax. Now, under the STC regime, we had these STC credits that companies could collect from dividends that they receive and set off against dividends paid out so that you don't pay STC. But very often, companies did not have access to reserves from dividends received, so there would be significant taxes paid when you pay out dividends. So there used to be this black market almost, where people would trade in STC credits. Companies that have built up significant reserves would pay out dividends to companies looking to collect these reserves so that they don't pay tax when they declare dividends out. So there was an active market for STC credits, much the same as there still today exists an active market for companies with assessed losses.
Yeah.
And this case effectively involved that. Mr. Taxpayer G appears from the facts to have been one of these structuring specialists who would go about collecting these companies with STC credits, manufacture them to a large extent, and then make it available to companies who would pay a fee for it. On Mr. Taxpayer G's case, with these STC credits being smuggled and sold to willing buyers in the South African marketplace, he would, of course, take a cut for himself as well, in the form not through a fee being paid, but retaining a 1% of the dividend that would be paid with all these STC credits, getting a 1% dividend as opposed to a fee for structuring it. And that was the essence of it, is whether that dividend received was part of a so-called impermissible avoidance arrangement, an impermissible avoidance arrangement being one that is, a transaction entered into solely and abnormally for tax purposes. And the court found against the taxpayer, said that, this is tax avoidance, it's impermissible tax avoidance because it meets all these requirements in the GAAR, and therefore, the assessments that SARS have issued stand. It is interesting because the case, and I'm sure we'll deal with it now, raises a number of interesting issues which I think need to be dealt with. Two perhaps interesting things from it. The first is the judge in the matter is Acting Judge Lewitz, who's an ex-student of mine when I lectured the GAAR at UCT in the LLM course.
Yeah.
And so I kind of smiled at that when I realized that. And the second is that the taxpayer apparently represented himself in the matter, did not have any counsel or lawyers assisting. And I think that is somewhat unfortunate because I think it made the representations to the court somewhat poorer, perhaps. So I think it made it was considerably more difficult for the court to arrive at a judgment that was perhaps well informed by case law and statute and the rest. And I say so respectfully, just simply because the court did not have the assistance of counsel on the part of the appellant, at least, to put forward the case of the appellant, supported by the relevant case law to support the facts of the taxpayer's approach.
Fantastic. Thank you so much for that. And to everyone listening, I think it is absolutely crucial, and that's also why this podcast exists, is to explain the necessity of having the right counsel, having the right people in your court, in your corner, fighting on your behalf and helping you to get to the best possible position, not just for yourself, but for your entire community. Albertus, I think when we get into the detail of this case, it seems like we have to go back to the beginning, the old GAAR versus the new GAAR.
Yes.
And the two, well, my understanding of the difference between the two is that the old GAAR had this subjective test to sole or main purpose, and the new GAAR has an objective test to the sole or main purpose. Can you maybe elaborate on the difference between the two?
I can. But before we get to that, as you said, we need to go back to the beginning. And we've had a GAAR, a General Anti-Avoidance Rule in this country, since 1941. We had the Income Tax Act of 1941 introduced at the time with the GAAR then in Section 90. And our courts have consistently held over the years that the GAAR, be it in its pre-old permutation or the old permutation, always consisted of four components. At least, initially there wasn't this abnormality requirement, but that was very soon introduced after 1941. These four requirements of an arrangement, transaction, tax benefit, sole or main purpose, normality. And we see that today still in Section 80 capital A. Now there is some debate whether, with all this redrafting of the GAAR in 2006, whether one of the requirements of the GAAR, the purpose requirement, to say what is the purpose of the arrangement, the transaction, whether that has changed. And there is some arguments, or there are some arguments being raised by SARS in a draft guide, for example, and there is some evidence of this perhaps in some of the explanatory memoranda behind the legislation in 2006 to say that the reason for the GAAR being redrafted is to change how we measure purpose from subjective, which it was previously, to objective. Now, what does that mean? What is subjective and what is objective? Well, the best way I think to explain it is to say it's the difference between how we measure intent versus negligence in criminal law, if you will. So if I'm on my cell phone whilst driving and I run over a red light and I hit somebody and that person dies as a result, that's manslaughter, potentially. Why? Because the element of guilt that you have is potentially negligence. How do we determine whether someone is negligent? We objectively look and say, this is what Albertus did. This is what a reasonable person would have done. Does Albertus's act, or does his actions live up to the standard of reasonableness that we have in the community? No, we don't. Therefore, he's negligent and potentially, therefore, liable to criminal manslaughter. Intent, on the other hand, is doing something, of course, intentionally. Now, of course, if I were to be found guilty of murder, someone needs to prove that I intended to kill someone. Now, how does a court do that? It's a subjective test. The court needs to say, what was the intention? It's something the court needs to climb into someone's mind.
The motive.
The motive, purpose, intent for it. How do I determine that practically? I mean, it's impossible practically to jump into someone's mind. So how do we do it? We look at objective indicators to determine it. You hear that the person threatened the day before, I'm going to kill you. They saw him lurking in the bushes outside of his house the evening thereafter, taking pictures of the surrounds. There are recordings of threatening phone calls being made, etc. Those are all objective indicators which we look at and we say, well, from those objective indicators, we can conclude quite comfortably that, yes, that person intended to kill the other. Now, in the GAAR, it's much less dramatic, but it's the same principle. Question is, when I enter into an arrangement, transaction, did I intend to avoid tax? That's how it used to work, at least, under Section 103, without a doubt. It was set down by the appellate division then, the GAAR case, and followed since by pretty much all cases thereafter dealing with GAAR, saying it's a subjective test. Yes, we can't jump into the mind of the taxpayer, but we look at objective indicators to tell us what the intention was. The argument is that it's now an objective test. In other words, we don't really care what you intended. All that we care about is what is the main effect of the transaction. If the main effect of the transaction appears to be tax-driven, then we're going to say that the main purpose of the transaction was to avoid tax. Simply look at the effect. Doesn't matter what you say, doesn't matter what other reasons or special circumstances may exist. If the main effect of the thing is to achieve tax avoidance, that is the purpose of the arrangement. That is what would be the case under an objective approach. What makes all of this very interesting in the case of Mr. Taxpayer G is that the court looked at this in quite a bit of detail, albeit that the court says, I don't really need to look at it, but ventures into this exercise regardless. And what the court effectively finds is that the whole purpose of all of this redrafting was to change the sole main purpose requirement from a subjective one, the intention of the taxpayer, to an objective one, just simply looking at what the main effect is. And the court found something quite curiously, and something which respectfully I disagree with, is to say that the new test is now somewhat more objective than was the case previously. Now, from where I'm sitting, Kosie, the case is, it's a binary question. Can't be more objective. It's either subjective or objective. Now, if you read through how the judgment then applies the sole or main purpose test to the facts of Mr. Taxpayer G, one realizes while the court says that, it's more objective probably, the court actually still applies the old test. Actually still applies a subjective test. I think perhaps, therefore, just labeling the new approach so-called incorrectly. What does the court do? The court says, look, I can't simply trust what the taxpayer says. I need to look at all the other surrounding circumstances, and from there I need to determine not what the main effect is, what the taxpayer intended. And from there, this is an objective test, and we see what the GAAR applies or not. Of course, it's not an objective test. It's a subjective test in that the court applies by applying objective criteria in the same way that we've always determined subjective for GAAR cases or for cases of murder.
Absolutely. And for someone that's not that deep into the technical world, my understanding then is if the both of us entered into exactly the same transaction, exactly the same contracts, exactly the same steps, let's even use the exact same values, but I intended 100% tax avoidance and you intended the real intention of doing those steps, then under the old GAAR, I would have been caught by the GAAR because my intention is tax benefit, that's my sole main purpose, and it's abnormal. But for you, that wasn't the case. So I would have been found guilty, but you wouldn't. But in the new test, my understanding is that both of us would either be guilty or not guilty, and intention is sort of sidelined.
So two comments, just briefly, you say been found guilty, which just reminds me of an interesting little quip. There was a Judge Conradi, who famously, in some of his, in the courts, I understand, unwittingly would have referred to the taxpayer often as die beskuldigde, the accused.
Die beskuldigde.
And of course, as taxpayers sometimes feel as though, we're being accused or guilty of tax avoidance.
Yeah.
Which of course is not the case. Back to your point, the point you raise is an important one because it says that, look, if based on the same facts, one person can be found guilty of tax avoidance, your words, or not, with the only distinguishing factor being purpose or intent. Is that the case? How does that work? And it is so. And why is that? It's so because the GAAR exists as a remedy, not as a backstop measure to where special anti-avoidance rules won't, apply. It's a backstop to ensure that taxpayers don't purposefully take steps to avoid tax through creating schemes. That's the ultimate reason why the remedy exists. And I disagree with the idea that the test has now changed. The test was, under Section 103(1), the old GAAR, that you look at the intention, the purpose, your words, the motive of the taxpayer. I believe that's still the case. Firstly, because that, in substance, is what Mr. Taxpayer G actually applied. Secondly, because that judgment is in any event not binding. It's a tax court judgment alone. And thirdly, I'm quite sure that that is the way that the legislation reads. And there are a number of reasons why that is the case. But to say simply that the legislation has changed, therefore the meaning of the words must have changed, I don't see that as a sufficient reason at all. If you consider the words and the context and the purpose of where that provision, the Solomon purpose test, applies, I don't see that there's been a change in meaning. So I think, it's still the case that, if you've entered into the same transaction as I have with a tax avoidance intent and I haven't, the GAAR can apply to you, not to me.
I completely agree. Thinking of an interesting topic, something you've got questions about, leave it in the comments and maybe we'll do an episode just for you. Albertus, I think we also need to consider the question of tax benefit. What really defines as a tax benefit?
So the question of what a tax benefit is, again, is as old as 1941. It's really a principle that's been in the GAAR for more than 80 years. There are a number of cases that have dealt with it, but effectively those cases, the principle in it has now been legislated. The tax benefit is a defined term in Section 1, but what it is to avoid, postpone or reduce one's liability for tax. As far back as King's case in 1946, the court has said, and quite emphatically, that what we're dealing with, of course, is you can't avoid a tax liability that has been assessed or that has already come about. The tax benefit that we're talking about in the GAAR is an anticipated tax liability that you're escaping. In other words, I see the tax coming down the road and I'm taking steps now to get out of the way of it. So how do we determine what a tax benefit is? There's been some criticism in this Taxpayer G case of some of the old tests that have applied. But one of the tests where there is significant authority, and I'm not sure that one could respectfully have deviated from these old appellate division cases, would apply the so-called but-for test. To say that but for this arrangement, would there have been tax? If there would have been tax, the transaction has the effect that there's no tax, then there's a tax benefit that is achieved by the arrangement. That is effectively what the principle involves.
Okay. When we start looking at specific anti-avoidance, right? So in the world of tax, we've got specific anti-avoidance for very specific things. Think of Section 8, 8C, 8E, 8EA, 7C, paragraph 43A. These are all specific anti-avoidance. I did something, that specific thing is being, let's say, caught.
Yes.
In the world of GAAR, my understanding or my feeling is that the more specific anti-avoidance I have, there's only so many tools in a toolkit that you can target. So if I've got an answer, if I put my SARS hat on, and I've got an answer for all of these different tools, is there still a need for GAAR at the end of the day?
Well, I think the facts of Mr. Taxpayer G show quite clearly that we do still need it. And look, of course, you can only go to the GAAR once you've applied all the specific anti-avoidance rules and none of them apply. So it is a remedy of last resort. Otherwise, there isn't a tax benefit, as we've just explained.
Yeah.
I mean, if a SAR, specific anti-avoidance rule, and I'm not one for acronyms, but it's what we call these things. Once a SAR doesn't apply, only at that stage can there be a tax benefit for the GAAR to apply to. But the specific anti-avoidance rules only go that far. And very often, the legislature doesn't foresee let's call it the ingenuity of taxpayers or their advisors often. Meaning that there are cases where you have tax avoidance come about, which may be perceived as going against policy or being impermissible, not what we want to see come about, practically speaking. And in those cases, it would either stand for government then to react each and every time by introducing new specific anti-avoidance rules, thus creating, I think, certainty to a certain extent, but also complexity. Or you can rely on this backstop, the GAAR. The interesting notion that you raise, though, is what would happen if we don't have a GAAR? In sophisticated economies like the UK, for example, only introduced the GAAR in 2014. So what did they do before then? Well, they didn't specifically rely on SARS, and not South African Revenue Service, specific anti-avoidance rules. What they did is they had a common law rule against tax avoidance. To say that, as almost a purposeful interpretation of legislation, that if you're going to rely on legislation in this or that manner, and it brings about a tax avoidance effect, then we're not interpreting the legislation correctly, and it should be interpreted differently. So as part of such an approach, which is far more pliable, I think, and capable of being developed over time, other economies have dealt with tax avoidance in the past. I understand that the Netherlands recently have abolished their GAAR for exactly the same reason, is to say that, look, we'd rather just rely on a judicial anti-avoidance rule rather. But where we are at the moment, and just the way that we interpret legislation, I would argue that there is still very much a place for the GAAR. It must, I think, be treated with circumspection, because it is ultimately, because it is a cover-all type of remedy. It is quite dramatic and draconian. Its effect is, of course, that the Commissioner can do with the transaction pretty much whatever it wants to pretend to do to bring about tax. But there is a place for it to counter aggressive tax schemes. But I do think that it is important that the principles, and that's especially why these new cases are so important, that under the new GAAR, our courts re-emphasize how the GAAR is to be applied, that it is applied with circumspection, and that ultimately the GAAR isn't applied as a penal measure or revenue-raising measure, but as a measure simply to remedy tax avoidance, to protect the fiscus, and no more.
I completely agree with that. My worry with the current Taxpayer G case is when we think about specific anti-avoidance and then the tax benefit question and specifically the but-for question, my understanding is that the objective test puts us in a position where the court can say, listen, a reasonable individual could take any other version of a transaction to get to the same outcome but would have a tax effect to it, and therefore tax you according to that made-up version of the new way how the court thinks. But I don't believe that's the only way you can think of it. There's multiple ways of getting to the same answer. Some have tax, some have more tax, some have less tax consequences. And yeah, I would love to have your opinion on, does this mean that all levels of sensible tax planning is ineffective, or we can't do anything because everything and anything would be seen as a tax benefit if you strictly apply the tax benefit and objective test?
So I think there are two examples, two principles from that. And it goes back to the anticipation of tax coming down the road. For there to be a tax benefit, you need two things. Firstly, you need tax to be coming down the road, objectively. There's tax charge on its way. Secondly, you need appreciation on the part of the taxpayer that there is a tax charge coming. Because how can you avoid and anticipate a tax liability if you're not anticipating it? It's just there all of a sudden. If that is the case, consider then the financier of a company injecting capital into that company. Let's say I inject share capital. I fund the company with preference share capital. Loan capital, debt capital was never an issue. It was never something we'd even consider. The financier was approached with a request to say, can you advance monies to us, the company, on a preference share basis? The financier says yes. What does the financier receive? Receives dividends. The financier is a company, receives tax-free dividends from a dividends tax perspective as well as from an income tax perspective. I think it's taking it too far to say that in that case, the financier has a tax benefit because it could have conceivably financed on interest-bearing basis, receiving taxable interest. And I'm not talking here about the choice principle and me electing which way to go about it. The comparator set down in Mr. Taxpayer G doesn't talk about purpose or anything. It simply says, if the arrangement could have brought about, objectively speaking, a worse tax position, and you are in a better tax position, then there is a tax benefit. And I don't see that as the comparator, because in my example, on that basis, based on that test, there would be a tax benefit for our financier. Whereas applying the old test of having an anticipated tax liability, which is appreciated and that is coming down the road, in our case, of course, our financier has neither of the two. It doesn't see a tax liability coming down the road because it would always have received exempt dividends. That was the only option on the table. And secondly, there's no tax that would have come about in any case there, on the basis that it's either tax-free dividends or nothing. So just to summarize, I agree with you. I think the test is being put too wide. To emphasize again, though, because it's a non-binding judgment. Of course, it is a judgment that is going to be raised as persuasive authority from here on going forward. But the principle, I believe, is respectfully set somewhat too wide.
Do you think Taxpayer G would appeal?
It's interesting. There's obviously quite a bit of money involved in the thing, if you read the judgment. I think there's been sufficient controversy around the judgment that there is, I think, quite significant grounds for appeal. Whether the taxpayer has the appetite to do so, I'm not sure. I can also tell you that I've tried to lean in on some of the gossip at the bar and so forth, but I mean, there's no indication or nothing I've heard at this stage whether it's going further or not. I really do hope so, because I do think that the judgment raises some issues which I think need to be settled by a higher court, just in the interest of certainty.
Just to circle back to one of your initial comments as we conclude, Taxpayer G did not have counsel. Do you believe that, or maybe not believe, but do you think that there could have been a different outcome if Taxpayer G had a good counsel, a good litigator or tax legal team behind him to assist him in the process?
I think there would have been a different outcome. And I say so for no issue related to whether the sole main purpose test is objective or subjective, and whether the but-for test is still there or not, or how you determine a tax benefit. There's one glaring issue, I think, that's being missed. Mr. Taxpayer G was ultimately assessed, the court found in favor of SARS, on the basis that there was this arrangement, the scheme of trading STC credits was quite clearly abnormal, and that the taxpayer did this solely or mainly to achieve the tax benefit, to realize the benefit for others from the STC credits. But when you look at a GAAR type query always, you start off with the very first question: what is the arrangement in question? What is the arrangement which was entered into to avoid tax? In our case, the arrangement in question isn't the STC smuggling, if I can call it that, the trading of the STC credits. It's quite simply that Mr. Taxpayer G decided to take his fee, his cut, from arranging all of this in the form of a dividend rather than a taxable fee. So it's very much the same as saying, is it tax avoidance if I, for example, in our financier case, decide to finance a company with share capital as opposed to interest-bearing taxable debt? Is it impermissible, is it tax avoidance for me to decide and to structure my affairs to get a tax-free receipt where as opposed to a taxable receipt where I have an option to either? And that goes down to a very basic principle in the Kosie judgment, which is a seminal judgment in the early 2000s, where effectively in paragraph 1 of that judgment, Judge Jeffer says, effectively that the taxpayer has a choice, this choice principle. You can arrange your affairs as efficiently as possible. And that really is the principle, I think, that should have been identified and argued by the taxpayer or his counsel in that case. Is to say that, yes, this entire scheme, all of it, is clearly abnormal. It brings about tax benefits for others. This is why I've entered into it. But did I do all of this for tax reasons? No. Mr. Taxpayer G did this to get something out of it, a fee. He just chose to take his fee and a dividend. That's not tax avoidance. That's tax structuring, tax planning. And under the CONAC principle, I would argue that is not tax avoidance in the sense intended by the GAAR.
Absolutely. Did you enjoy this episode? Please like, subscribe, and share with your network. Albertus, thank you so much for that. Thank you for sharing your insights. I really appreciate it. As we close off, just a last comment or a question. How can our listeners get a hold of you guys? Specifically, I know you guys draft tax opinions, you guys do tax administration, but you guys also do litigation and you assist with court proceedings, etc.
Yeah, so the website is there, ajm.inc. Our contact details are all there, and welcome to be in contact.
Fantastic. And that's a wrap. Thank you very much for joining in today in this session with Albertus discussing GAAR and specifically the Taxpayer G court case. Thank you very much. We at Baker Tilly Greenwoods strive to be trusted advisors. If that is who you are looking for, please reach out to us via our website, bakertillygreenwoods.co.za.